Alrighty, it is 12:02. Thanks for joining, everybody. My name is Ross. Again, I'm a librarian with the King County Law Library. Today, we're going to be talking about adult guardianship and its alternatives. This is a somewhat new and somewhat complex area of the law. A lot of changes happened. It was last year. So it's still new. It feels like it's still evolving. And I have members with me today. Member of the ex parte department, Nadia. We have a good chunk of time reserved at the end of the hour devoted to Q&A. Following my presentation, that's going to be mostly about the mechanics about how this actually works. A little bit about the library before we get going. We have locations in both the Seattle and Kent courthouses. We offer books, of course, but also many databases, some of which can be accessed at home from our website, which is kcll.org. We make videos, we make infographics, all to help you understand court processes and actions. And lastly, we also work with attorneys to put together form packets. So these include forms that you need for certain actions that the state doesn't provide for whatever reason. So forms for starting a lawsuit, probate, so it's the forms, but also instructions on how to use them. We don't have any in-house forms on guardianship yet, though, but stay tuned. So the forms, the videos, the infographics, databases, those can all be accessed online at kcll.org. Here's an overview of what we'll be discussing today. We're going to be talking about adult guardianship. What is it? What changes were made from the old guardianship laws for with the new laws? What changes should existing guardians see? Now, we're also going to be talking about alternatives to guardianship, such as supported decision-making, protective arrangements, conservatorships, then things like emergency guardianships, and then other resources. So you can see we're going to be starting with a very broad view of the topic, and then we're going to be getting more into the nuts and bolts as we go. And not listed here, again, we will be having Q&A at the end of the hour. A little disclaimer, I am a librarian. I have a master's in library science, but I'm not a lawyer, so can't give you advice per se. This presentation is a synthesis of many existing resources that are out there, but it's also a very, like I said, a new part of the law. It's an evolving part of the law. Because it's new, because I can't give legal advice, it makes sense that you may need to consult with an attorney. One other disclaimer that I'm going to head off. One thing first, this is being recorded, so we're going to be making an edited version of this. Like if I talk about links or something like that, we're going to put the links into the video, embed them. So look out for an edited video of this recording. That'll be available on our website later. So this will be made available later on. And then another thing is that I am recovering from an illness. So if I go on mute suddenly, sounds like the audio cut off, it's probably the case that I'm having a coughing fit. I have a cough drop in my mouth. My aim is to have a cough drop in my mouth constantly. King of TMI over here, but in case you're wondering why it sounds like I'm talking with something in my mouth, or why I'm not talking at all, that is the reason. So let's actually get into it. Starting with a fairly broad view of the topic, like I said, this is about as broad as it gets. If you have questions about adult guardianship, people come into the library and they say, what is the basis for whatever? What is the basis for adult guardianship? Here are the statutes. RCW, the Revised Code of Washington, 11.130, specifically Article 3, that's about as authoritative as it gets. Looking at statutes is helpful in many instances, such as we're going to be talking about who needs to be served in the case versus who just needs to be notified. So if you're saying who gets notice, who is that? Well, look at the statutes because they have it written out precisely. It can be tedious to parse the legal language involved in statutes, but and so with that, sometimes it makes sense to consult secondary resources first. So we'll be looking at those. But for a lot of questions, you're going to want to start with the statutes. So let's actually dig in and see what's there. Oh, no, I don't do that. So the way I set this up is I'm talking about those secondary resources. So looking at the statutes, I had to draw on a few resources. I think the main one that is important is that the family law facilitators in this third category under King County, the family law facilitators have a packet of forms, kind of meager instructions just saying complete these forms and file them on adult guardianship for how to kick off a case. So that's super instrumental. I don't know of much else out on the web for adult guardianship for kind of like a step-by-step process. Like I know Washington Law Help is great for talking about alternatives to adult guardianship, or if you're talking about minor guardianship, they have a step-by-step process for minor guardianship. But there's not really a lot out there for adult guardianship. So using the Family Law Facilitator's Guide is super important because it tells you exactly which forms that you need to fill out. Those forms are available right there on the state website. You see where Mr. George Washington is. All those forms live there. And then, like I mentioned, we'll be talking about alternatives to guardianship, and that is where Washington Law Help is going to be super important. Okay, here we go. So this is still a bit broad, but if you're attending this webinar, you probably know what a guardian is and what a guardian does. But just to be sure, a guardian is a person appointed by the court to make decisions with respect to the personal affairs of an individual, right? So the court can appoint them to make decisions about health, safety, and self-care. This can cover many areas of somebody's life: healthcare decisions, interpersonal to a certain degree, interpersonal relationships, financial relationships. Note that guardians that are strictly concerned with someone's finances, they're called conservators now. But the process for obtaining a conservatorship is about the same as a guardianship. So these definitions come from the new set of laws listed there at the bottom of the page, 11.130. It's not 11.88. It's not 92. Those laws are largely toothless now. It might go without saying, but something to make clear that this hour and the laws and procedure we're discussing, this is for adult guardianship. Minor guardianship is its own thing. We talked about it last week in a webinar, and that's going to be, we have a video that we're working on of that kind of edited recording file. We're going to put that on our website soon. So if you want to watch that minor guardianship one, check our website soon. But what we're talking about today is not going to be applying to minors. So here's a list of the major changes that occurred between, the big changeover in 2022. For my segment today, we're mainly talking about, getting the process going. And so the major change with that will be the third bullet point, which is talking about notice. But these are all critical components to bear in mind. So the finances I kind of talked about, there's conservatorships now, different types of approval. You can read it there on the page yourself. So the court will appoint a guardian when they receive a petition, right, and the forms that we're going to be talking about. But they'll actually appoint a guardian when one of these criteria is met. The person called the respondent, the person who will have a guardian, that's the respondent, if they're unable to meet their basic needs on their own, if they're unable to receive and evaluate information or communicate decisions, if there will be significant risk or harm to the adult unless a guardian is appointed. So that's kind of a high bar to clear already. But also, the new state laws state that if the respondent's needs, the person who might have guardianship over them, if the respondent's needs can be met, if the criteria on the last page, if that criteria can be abated in other ways, the court may not appoint a guardian. So, in some ways, guardianship is the last stop for assisting the respondent. You essentially have to prove that there are these other alternatives, but they're not going to work, that you've tried other things, but some harm will still befall the respondent unless the kind of drastic step of guardianship is taken. So, a very simple example would be if a respondent simply needs someone to sign legal or financial documents for them, they probably don't need the very restrictive confines of guardianship, where guardianship has reporting requirements. Obviously, it's its own court case. Sometimes with a guardianship, you lose rights, like the right to voting. In this example, if the respondent just needs somebody to sign on their behalf for financial documents, then just pursue a power of attorney or something like that. You don't need the very strict confines of guardianship at that point. So in some ways, less restrictive options need to be ruled out before a guardianship is established, or if the risk of harm is so imminent or obvious that obviously it's necessary. So what are the alternatives? Here are four of the common ones, and I have even more listed. We're going to be talking in depth about these and more later on. But anyway, there are solutions such as supported decision making, which is somewhat like a contract between the respondent and a trusted friend. So this isn't achieved through the courts, with like a petition or whatever, but it's simply an arrangement that lets someone lean on someone else to make decisions. The document itself outlines the type of help needed and when, so it kind of sets the boundaries in that document. There are also protective arrangements and conservatorships. Both of these use the same petition as guardianship for getting started in the courts. And if you're seeking a guardianship out of the gate, the courts may bump it down to one of these less restrictive options. So protective arrangements are the least restrictive option of the three being, again, guardianships, conservatorships, protective arrangements. Protective arrangements are the least restrictive of those. Conservatorships, as I already mentioned, those deal solely with financial decisions. So those two and full guardianships use the same paperwork to get started, and we're going to be looking at that paperwork shortly. Lastly, here I'll also mention emergency adult guardianship. So this is seen as a short-term solution or a short-term option for versus the full guardianship. So emergency guardianship is just 60 days off the bat. It can possibly be extended, but the understanding is that 60 days is not a very long time. There's just some kind of immediate, you could say, emergency type need. But anyway, like the full guardianship, for the emergency guardianship, you need to prove that no other option exists without harm befalling the respondent, right? So we're going to be talking about this option a little bit later on in the hour. I was just talking about how you need to rule out the least restrictive options first. So in some ways, it might make sense to start with those, but this is a guardianship webinar, so we're starting with the full guardianship. We'll be talking about those alternatives as the hour goes on. So in short, you'll be completing the initial forms. We'll be making copies of those, filing the originals with the superior court clerks. And then you'll be scheduling hearings and giving notice, serving the initial forms on the respondent and other parties, and then attending the hearings. Of course, there's a lot more to guardianship than that, right? I mean, you're talking about a human's life. But helpfully, once you initially file, you'll be given a document that's called What to Do Next, which outlines in detail what you actually need to do. So my goal today is kind of outline these initial stages to get you to that What to Do Next document. So looking at the forms that you're going to be completing to get this process going, first here is the petition. This is, I think, the longest of all the forms, and it's the most in-depth. A petition in most any court case is what kind of kicks it off. It's no different here. First, you'll have to provide information on the person in need of guardianship, that respondent, and then yourself, the person who's filing the petition, meaning you are the petitioner. You'll have to describe thoroughly why a guardianship is necessary for the respondent and why other arrangements won't cut it. You'll also have to establish the scope of the proposed guardianship, as well as information on the respondent's, life, like their financial information and their other type of relationships like that. There's a section that describes any proposed limits on the respondent's rights. So guardianships in many ways are customized to the individual and their needs, but the big picture on guardianship is that there is some inherent loss of rights, right? Like somebody else is determining the course of your life in some ways. So what rights need to be limited, if any? Lastly, there is an appendix there where you're going to be listing the people that are important, people that are legally important to the respondent. These are the people that are going to have to be notified about the arrangements. So this is an 11-page document. It's important to be very thorough and careful, as with all court forms, of course, but petition is the one that kicks it off. So be mindful there. There's also this personal information form, the PIF, which, like the appendix on the petition, it has you list people and then their relationship to the respondent. So this is another way that you can suss out who needs to be notified and all that. And also the court is made aware of these people as well. There's also the order appointing a court visitor. So a court visitor is a person appointed by the court who needs to interview and get in contact with the parties involved and give a neutral report about what's happening. So this form exists to get that person involved, the court visitor. There's also this sealed cover sheet. Given that guardianships often deal with either healthcare or financial information, this serves to restrict public access of these documents. So it might be important to file something relevant to Medicaid or JP Morgan document. But anything you file with the clerks, the public can access. So you put the sealed cover sheet on top of it to prevent public access. So also the notice documents, which let others know that a petition has been filed and that a hearing is taking place. Then there's a separate notice for each of these, for the notice of petition and then the notice of hearing. Note that for the notice of hearing, you're going to have to file your petition first to receive your hearing date, right? Because how would you know what the date is before that? But once you filed, you're given the hearing date. You can fill in the blanks and let the other parties know about when that is. But on the subject of notice, who needs notice? What is notice? The statutes spell out quite a long list. This is pretty much copy and pasted directly from the statutes. Long list of who needs to be notified. The people that need to be notified that a hearing is taking place because they have some kind of legally defined close relationship with the respondent. You can see that, spouses, children, but then the list works down to where the statutes say any other notice party there at the bottom. So that's, the court can say anybody else who's important that way. But notice that the respondent isn't listed on that page, nor if that person has the respondent has an attorney, that person's also not listed. That's because the respondent and a few other people need to be served. Here is a deck. Who needs to be served? So what is service of process? The library has a good 10-minute long video that walks you through service of process. It probably could be its own hour-long class. But that's available check out the video on our website because it's very thorough. But in short, service of process is a legal process. Oh, here we go. So you can read that there on the page. The idea with service of process is that when you're starting a court case, guardianship, a lawsuit, divorce, whatever, It's pretty serious, and the first step of actually letting somebody know that they're being sued, that a divorce is happening, that someone is trying to establish guardianship over you, the court needs to make sure that that person's actually been alerted that this is happening, right? You can't just shoot them a text or something. So this is the official court process of personal service. So this is when a third party, somebody who's not involved in the case at all, personally hands over the documents, and then under threat of perjury, tells the court that they've given the documents. So that's that declaration of service document we saw a couple slides ago. There's more to it than that. In certain types of cases, you can serve people through the mail, but you have to ask the court for permission. It gets a bit involved. I would watch that video on the library's website to get a full scope of what personal service entails. So now that you've seen the forms, or a few slides ago we saw most of the forms, it's worth talking about making copies. Once you've filled out those forms, you're making copies for everybody that you either have to serve or notify. Based on those last few slides, you'll make copies for all those people and a set for yourself as well, because the original forms are going to be the forms that you filled out originally. Those are filed with the clerks. The originals go to the superior court clerks, and everybody else just get copies. So take it all together. So far, you know which forms you need to start a guardianship case. You know that you need to make copies, file the original, and then you'll be serving and notifying folks with those copies. So when you file, you'll be given this what to do next document, which outlines all that you need to do before your hearing. This includes attending training, giving the courts information on your financial and criminal history, taking out a bond if you're operating as a conservator, I believe. That document is very inclusive, so I won't reinvent the wheel by repeating it all here, but it can be found online on the ex parte guide. The ex parte department has a really good guide on their website talking about guardianship and just their workflow, and they have a copy of this embedded in that. So after filing, you're going to be preparing that notice of hearing. You'll be given the hearing date, so you can use the notice of hearing at that point. You'll be serving the people that need to be served. You'll be notifying the people that need to be notifying. You'll do that disclosure of bankruptcy and criminal history, online training, do everything that you need to do to prepare for the 60-day hearing that's found on that form that we were just talking about. You'll attend the 60-day hearing, and then you'll attend the final hearing. And these things can work out in different fashions, whether it's super contested and needs to go to trial or whatnot. But after appointment of guardianship, I think the main thing is that you have to give notice within 14 days, file your guardianship plan with the court, and that's all within 2 weeks after appointment. And then 30 days afterwards, you have to provide notice about the respondent's rights. Remember, because guardianship directly affects the respondent's rights, they have to be alerted that this is the case and how that's affected. And then long-term, guardianships must file reports once a year, and they can petition the courts for instruction as needed. So this is for cases where you need the courts to provide documentation that a guardianship extends over certain areas. For instance, if the guardians need to access a certain bank account, does the guardianship extend to that? You can ask the court you can petition the court to make that clear. Here's one slide that I have for existing guardians, like pre-2022 guardians. My understanding is that if you have, you had guardianship going before then, nothing really needed to happen until your next review hearing. I think enough time has passed, hopefully, that this is largely unnecessary. But anyway, the next review hearing, the courts may offer some recourse at that time, including information on how to petition to kind of change over the type of case. But I think that they're mainly having you wait until that hearing. So if you still have not had a hearing, I don't think they want you to do it in advance just to not inundate the courts unnecessarily. But then for reporting, you'll use these forms that are listed at the bottom of the page here, 204, 205, and 206. Okay, I've already mentioned multiple times that there are alternatives to guardianship. And then I have even more in the next page that we're going to go even more in depth on. But these I'm just going to talk about real briefly. So living trusts let you put money or property in a trust that's managed by somebody else while you're still alive, right? So I think of trust as something that manage your estate and property after you pass, but living trusts are an option to be used during your lifetime. Now, living trusts and just trusts in general are very complex. There's not a lot of explainer articles or like how-to guides on the web. This is kind of territory where it's time to talk to an attorney. Then there are representative payee. Now this is just relevant to public benefits, so like Social Security. Social Security, pays benefits to beneficiaries, but if a beneficiary cannot manage, their own benefits, Social Security can appoint a representative payee to receive and manage the benefits. So the representative payee could be a person, it could be an organization. There's a good article about this on Disability Rights Washington. It's a great local nonprofit. They have information on their website about this. Joint banking is when two people are on a joint checking or savings account, and then they can both manage the money in the account, even if one of the other person becomes incapacitated. Joint banking comes with risks. One joint owner could take out all the money without the other person's authorization, so that's a pretty big risk. If one joint owner has debts, the creditors may come after all the money in the account, right? They're not going to try to divvy it up at that point. It might be safer to make someone who wants to help what's called an authorized signer to an account, or to use power of attorney, which we're going to be talking about more. Next, there's also joint property arrangements. So some people choose to own property together so that if one becomes incapacitated, the other can manage the property. This is something we have desk books in the library that talk about this, and this is also verging on territory of time to talk to a lawyer, but that's an option. There's the consent to healthcare law. So Washington has an informed consent law for adults that lists specific people who can make healthcare decisions for a patient who doesn't have capacity to make decisions for themselves. So it's kind of a hierarchical list for who falls where priority wise. So for all of those consent to healthcare law and above, Washington Law Help has a great article talking about all of these. And it's laid out pretty thoughtful. I think that'd be worthwhile to read that. There's also vulnerable adult protection orders. That's another option for, this is more for like elder abuse or like abuse of otherwise vulnerable adults. So these can limit access to the adult. It can limit contact, stop financial exploitation. For more information about this, I would reach out to the protection order advocates in the courthouse or the protection order office of the superior court clerk. Washington Law Help does have an article on VAPOs, but I think talking to a courthouse department would also help, because there's also a limit to how much a protection order what can a protection order really do. Don't get me wrong, they're super important and capable, but not everything's one size fit all, right? So we're talking about alternatives to guardianship that could be an option there. So here are all the alternatives that we're going to be talking more in depth about. So there's supported decision making, durable power of attorney, healthcare directives, protective arrangements, conservatorships, and emergency guardianships. So supportive decision making is when a person who we've so far been referring to as the respondent, they choose a trusted friend to help them understand and make decisions and to communicate decisions to, for example, doctors in the bank. So this is what I referred to earlier where it's kind of a contract between two people. So the supporter, the person doing the supporting, they might use rhetoric to help someone make a decision, or they might assist the person with like technology. Um, but this is all going to be outlined in the agreement itself, which is going to set the boundaries on what types of decisions need support and how they are going to be needing assistance. So there's actually a great packet for this on Washington Law Help. There's also power of attorney, durable power of attorney. Power of attorney lets a friend or family member who's known as an agent. The agent will help you make financial or healthcare decisions. This person can sign documents like they're you, like supported decision making. It's a signed document between the adult and the helper or the agent, without much in the way of court approval. It's not a court process. It does have to be notarized, but you're not actually filing this with the courts. For power of attorney, I send you once again to Washington Law Help. Love those guys. Also, I think Washington Law Help's power of attorney packet is fantastic. That's the resource we send people to in the library. But what's worth pointing out is that if you're looking elsewhere on the web for power of attorney, note that it says here durable. So durable means that it still applies even if you're incapacitated. If it doesn't have that word durable and it's just a generic power of attorney, the power ends when you're incapacitated. But incapacitation is the scenario that people usually want a power of attorney for. So if you're getting another one online, make sure it has a section on durability. Then there's healthcare directives. These let you lay out exactly what kind of medical treatments to which you consent in the case that you're incapacitated. So like a power of attorney, rather, it's signed in front of a notary. But unlike a power of attorney, it doesn't let someone else make the decision when you're incapacitated. It's all you writing down in advance what you're okay with. So there are healthcare directives, kind of generally speaking, there are healthcare directives that are specifically for mental health as well. Again, for this, Washington Law Help has some great packets of versions of these that you can use. Okay, so far, let's say all those options that we just talked about, those options aren't going to fully protect the person that you have in mind, the respondent. So that's where more restrictive options come into play. So first, we're talking about protective arrangements. So protective arrangements use the same paperwork to get started as guardianship, but they're nowhere near as restrictive. So there aren't always reporting requirements for protective arrangements because the court is usually authorizing a very specific task or arrangement, whereas full guardianships are much more broad and much more restrictive of rights. So a good example of a protective arrangement is one that lets a third party supervise, let's say, certain types of visits between the respondent and somebody else. So you can see how that would be necessary to have somebody supervise visits, but it also doesn't require an ongoing formal reporting process or other types of restrictions that you see with guardianship. So if a petitioner comes in and they are seeking guardianship for a case like that, because the petition is shared, the court, commissioner, or a judge can just bump it down to a protective arrangement if necessary. To that end, I've kind of already touched on this, but all the forms that we looked at earlier in the hour for guardianship, all of those apply for the protective arrangement. So if you know out the gate that you're looking for a protective arrangement, those are the forms that you're after as well. There are also conservatorships on that same petition. So again, a conservator is somebody who's appointed by the court to make decisions about finances and property specifically on behalf of another individual. So a court may appoint a conservator for an adult when the adult is unable to manage their property or financial affairs. So this applies if somebody can't evaluate information or make decisions about their estate on their own. For example, if they're mentally unable to make those decisions. But it also applies if they're being detained or they're going overseas or something like that, and they physically cannot be there to make those decisions. There's still that requirement that significant risk of harm to the adult or their property has to be there for a conservator to be appointed. But you can see how, for example, power of attorney or joint banking accounts, they're seen as like a less restrictive option to conservatorship. So you have to kind of see how those won't work. That you have to exhaust the less restrictive options before a conservatorship is sought or appointed. Last of the alternatives we'll be talking about today is emergency guardianship. So again, this is very much like the full guardianship, but it's limited time-wise, right? So 60 days can be renewed, another 60 days for 120 days. It could be seen as like a stopgap. I'm not sure how the actual procedure is functioning these days, but if it takes 60 days for a full guardianship to get started, is the emergency guardianship to be used as a stopgap, or is an immediate order possible? That's a question that I have right now, and I'm wondering if Nadia can speak to that when we're getting into Q&A. But emergency guardianships, anyway, use a whole different set of forms, and that's in a whole different section of the Washington Court's website. So it's the same procedure, it's just a different set of forms. Oh, yeah. Well, I have this slide here about immediate orders. So for immediate orders, you have to prove that some immediate harm is going to come from providing notice and actually going through the traditional route, right? So this is somewhat complex and kind of hard to pin down, but you'll have to schedule an emergency hearing. But do know that if you get an immediate guardianship, you're going to have to give notice within 48 hours. That's it for the alternatives. I just wanted to make sure. Oh, excuse me. We have videos and flyers on our site that walk you through how to schedule a motion hearing. There's supposed to be an embedded video, but it's not there. And for e-filing, the Superior Court clerks have good explainers on their sites. But with 18 minutes left in the hour, I'm going to be turning it over to Nadia, or I'm going to be leading the Q&A with her. So let me get over there. And for the questions that are answered, I'm just going to kind of verbalize them so people can hear it if maybe they are have several windows open or something like that. But someone said, how do we contact the library to request form packets? So that's done through our website, which is kcll.org. There's a link at the top that says forms. So you can request the form packets to be delivered as a PDF, which you can type into. So that's like a download option, or you can choose to have us mail it to you for a little bit more for shipping. You're also welcome to come into the library and purchase those in person. May we have access to the presentation deck, please? Yep, I can attach that to the video that we're going to be posting to our site, so stay tuned for that. Someone said on the website above, how do families know which forms they need to complete versus which ones the court complete? Nadia had answered, for the most part, the court does not complete any forms. You complete the required forms, including proposed orders when required. The judicial officer normally only signs any orders and may make changes to what you have proposed. We see that in the library often. The idea with orders, generally speaking, is that you fill them out as if you're the judge ordering exactly what it is that you want, and hopefully the judge or commissioner will agree with you and simply sign their name at the end. They might request changes or something like that, but you do complete those on your own. Someone asked, are the forms available in languages other than English? Nadia says that some forms are available in other languages. However, guardianship forms have not been translated. So I know like divorce forms definitely are, in Spanish at least. Someone else asked, the reporting requirement is annual. I thought triannual. Nadia said the court may set review interval at annual, biannual, or triennial. Am I saying that right? In most cases, particularly for new or self-represented guardians, the reporting period is 12 months. The court can consider extending the reporting period following approval of the first report. Then Nadia helpfully linked the statute there.
So I'll keep going. So there is a question in the chat about filing for an emergency guardianship, and this can be a little bit confusing in adult cases. There isn't a motion for immediate guardianship in adult guardianship cases. So if you are filing for an emergency guardianship, it's a really important distinction that you actually have to file separate cases. So if you're going to be seeking a long-term guardianship and an emergency guardianship, those are two separate case filings with two separate petitions. If you're filing in King County, when you file your petition for emergency guardianship, you will need to set a hearing in the ex parte department, and there are instructions for that available on the court's website or at the courthouse if you would like to go in person. And at that hearing, if the court finds that there's enough evidence to support a temporary emergency guardianship, then one can be granted for a period of 5 days, at which time there is a review hearing, and then a secondary hearing is, or a third hearing rather, is set to review for whether or not a 60-day guardianship can be set. And so the way that the court sort of accomplishes entry of the immediate emergency guardianship is just via the order. And I don't remember the form number offhand, but there are two separate orders. One is order appointing immediate emergency guardian, and one is order appointing emergency guardian. And there's a question about community organizations that support families and filling out forms and navigating processes. There are a lot of different organizations locally that support people in filling out their forms when they're self-represented. The court has the Family Law Information Center, which helps people with filling out forms, including some guardianship forms. And information about that, I can put it in the chat before we leave, but it is available on the court's website. They have appointments and some walk-in services. That program definitely is at high capacity though, because it helps with a lot of family law cases as well. What I recommend is if you have internet access to the internet, that you access lawhelp.org or lawhelpwashington.org, because that website has a directory of all of the local organizations that provide services in different areas of law, and it can sort of make you connect you to the right service potentially that can help you with your forms.
One thing I'll plug is that the library has a kind of new and emerging program every Wednesday where an attorney comes in. It's called the Family Law Forms Lab. So the idea is that you bring your family law forms that you're working on in, fill them out, and then as you're working, if you have questions, there's an attorney there to help you with it. It's not intended to be legal advice of like, what course of action should I take? It's more so like, what does this mean on the page? What should I put in the blank? That type of thing. It's not being held today. Our attorney is out today. Today's Wednesday. He will be back next Wednesday. It's every Wednesday from 2 to 4 in the Seattle location. If you're an attorney listening and you think, that sounds fantastic, how do I get involved? Reach out to us at the library because we're looking to expand the program and would love to hear from you.
That's awesome, Ross. And it's really important, especially if you're self-represented, that you fill out your forms as completely as possible, especially the petition. So RCW 11130 is very specific about what has to be included in your petition for guardianship. And so oftentimes we'll see people who file and they haven't filled out their forms completely, sometimes to the extent that the court can't move forward in your case. And as Ross mentioned earlier, when you file, one of the next steps that the court takes is that it appoints a court visitor and often an attorney in the case to sort of investigate and facilitate the case moving forward. And if you haven't included in your petition all of the reasons why a guardianship is necessary, or some you've left things blank, it doesn't allow those people who have been appointed to assist the court in moving the case towards finalization in understanding why a guardianship might be necessary. So I would consider that when you're filling out your forms, to try to be as complete as possible. I'm going to put a link in the chat here. And so there's a question, which is, can you file an emergency guardianship in the same case number as a non-emergency guardianship? And so the answer to that is no, you may not. And it's unfortunate, but it's just the way that the law is set up, is that it requires a petition for an emergency and a petition for a regular guardianship. And anytime that you have a separate petition, it's considered a separate cause of action, and that means that a separate case number is required. However, in King County, what we do to sort of maneuver around that is to consolidate the cases so that you will ultimately end up having one case number, and it should be the regular or long-term guardianship case number if you file them at the same time. I think that's the best practice, if possible, is that you file both the emergency and the regular guardianship at the same time. And then when you receive your order appointing court visitor, attorney, etc., sometimes called a case management order, it will have already consolidated the cases. And so you can refer to that for which case number you should use moving forward. And I say that totally acknowledging that that's not efficient necessarily, but it's the way that the law is set up, or at least the way that the court has interpreted the law is set up right now. And so that's how we are managing these matters. And so in the chat, I included a link to a summary of changes and a plain English guide to how the ex parte department in King County or the probate department is administering guardianships. And it does answer some of these more nuanced questions, like is a separate case number required? It also talks about which forms are required and sort of what the local practice is. It was written before the law went into effect, or around January 1st, 2022. And so certainly there have been a few adjustments here and there, but the bulk of it remains true. And I would use it as a guide to any filing and to answering a lot of the questions that have come up here today. I also answered in the chat. So just so the court offers interpreter services for people who need assistance accessing court services or court events if they are non-English speakers. And that includes if you use the facilitator's office, then if you make an appointment, then I believe that you can arrange for, if it is obvious that an interpreter is needed, or if someone asks for an interpreter, then that is something that those court staff will assist in setting up. It might mean that there's a delay if we have to schedule someone, but that is an option that's available. Usually when people access the courthouse, if they need assistance and we can't use an interpreter and it's not a court hearing, we'll use language lines so we can at least sort of get someone on the right path. And then some of those community organizations also offer interpreter services. And then just one other thing, which is, again, a person is entitled to have an interpreter at any court event if they need one. And so if you are an attorney or you're a court visitor or an attorney for a respondent and you need an interpreter, you can contact the Office of Interpreter Services. And those services are free for people who, in the vast majority of guardianship cases. So I really recommend that you do that. And that also includes for court visitors and attorneys for any meetings that you need to have with your client or with the respondent in the course of the investigation before the actual hearing itself. There's a new question. I missed the part about a motion for immediate guardianship. There's no motion. So if you're asking for an emergency guardianship and you would like to ask the court to enter an order immediately in King County, then you will file your petition, and then you can file a notice of hearing and set a hearing on the emergency motions calendar, which is every day at 2 and 3 p.m. And then if the court finds that an order is needed immediately, there is a specific order form for that, which again, I should have had it up, I'm sorry. But that will be entered temporarily. So basically you just file your petition and then you set a hearing to have the court review facts that you provided about whether or not an immediate order is needed. So there's a question about cost. It's $240 to file for a guardianship, but a fee waiver is an option in a lot of cases, particularly if the person who's subject to the guardianship is low income, or if them paying the filing fee could cause a hardship, right? So if a person doesn't have any income, or they don't have a lot of income, or if maybe they own a home but they don't actually have a lot of cash, then you can ask the court for a fee waiver, and that's something that you can do when you're filling out the petition. There's a space on the form that asks whether or not you're asking for the filing fee to be waived. And there are a lot of other resources online, including the state court's website has an information sheet about filing for guardianship. They also have a training that Ross mentioned that's mandatory that non-professional guardians must take. And I believe that my recollection of having taken it myself is that it does discuss the notice provisions there. So I think that that's a really helpful tool, even if you're an attorney or a court visitor who's a non-attorney. I think it's helpful to take those trainings so that you understand and have received, what information the person who may be becoming the guardian has received as well in a plain English way. If you have to file, I'm sorry, I can't recall if I said it or not, it's $240 though. Again, the fee waiver is based on the person who's the respondent in the guardianship. It's not based on your income, although in some cases the court could order that a person who filed for a guardianship pay the filing fee if it found that it wasn't filed in good faith, or if it found that person could and should pay. But in the vast majority of cases, it's based on the respondent income. So there's a question, which is, will the judge require documentation that shows a less restrictive alternative has been attempted? So when you're filing your petition, there are questions on the petition about why a guardianship or a conservatorship is necessary instead of some other protective arrangement. It will also ask you, or some alternative, it'll ask you also if there are other arrangements in place, like a power of attorney, for example. And then if you are not asking for another protective arrangement, but rather a guardianship or a conservatorship, then the court visitor is required to provide to the court in its report information about what alternatives, if any, have been explored, if you will, and why or what evidence suggests that those alternative arrangements may or may not be the best choice for this particular individual moving forward. What evidence is required is something that you can review in the statute, and I would in particularly review what the section of the statute about what is supposed to be included in the court visitor report and what is supposed to be in the petition. So we're running out of time, so I'm just going to make a plug. Usually Commissioner Brad Moore joins for these trainings, and he's at the judicial conference right now, so he wasn't able to join and assist us. But what I want to say is that if you are an attorney and you are watching this training and you are not a court visitor or an attorney, that I really encourage and ask that you consider applying for those registries, because we do not have enough court visitors and attorneys for respondents to administer the number of cases that we have filed in King County every month. And so even if it is particularly attorneys for respondents we're in serious need for, the vast majority of respondents are entitled to have an attorney appointed to them at public expense. And we only have maybe 40, at most 50 attorneys who are serving in that role, and about nearly 1,000 guardianships that are filed every year. So I'd really like to encourage you to consider doing that. And you can contact me, nadia.simpson@kingcounty.gov, if you have any questions about that.
All right. And with that, we are at time. Thanks for all the great questions, everybody, and thanks for attending. I hope that you all learned something, and I hope you have a good rest of your day. And then stay tuned on KCLL's website for a recording of this. Thanks again.